Good morning, Taylor Gang. Good morning. Happy Thursday. It is June 12th, and we are on to our next trial. We are going to shift gears and we're going to go over to the Atlanta rapper Cash Out's trial, who is down there in Fulton County, y'all. Gave y'all a little preview yesterday because we saw Lawyer Love in the courtroom as well as Mr. Matthews. Okay, we having us a little YSL reunion. So I have us queued up. What I anticipate is we'll get through whatever they got through on yesterday, and then we'll try to catch up with today. Karen Reed is actually out. Well, I don't think they're out. I think they're having the charge conference today. And so we'll pin over there and see what's going on. But will be our main focus will be the Cash Out trial. So again, like I said, we're going to start from the beginning. We're going to start from these opening arguments. And look, there goes Matthews already here. I believe that Cash Out is facing charges for RICO, sex trafficking, and rape. His co-defendant, I believe, is his mother, y'all. So make sure you got your notepads out. Make sure you're taking good notes, and that we keep the conversation going in the chat. If you haven't hit the like button already, make sure that you do so. Also, make sure that you subscribe if you haven't done so already. Let's get this party started.
Aggravated sodomy, trafficking a person for sexual servitude, aggravated assault with a weapon, false imprisonment, pandering by compulsion, possession of cocaine, tampering with evidence, willful obstruction of a law enforcement officer, and pimping as set forth in the indictment, and a true verdict give according to the evidence, so help you God. If so, please answer, I do. All right, thank you, ladies and gentlemen. You may be seated. Ladies and gentlemen, we are now ready to begin the trial of this case. I have some preliminary matters to discuss with you. I've already introduced my staff, and I encourage you to approach them if you have any questions. You will report to the hallway that you just came through, next to courtroom 8C, and ring the buzzer always that says Judge Leftridge next to it. You will be buzzed into the hallway, and you will proceed to my jury room. Ladies and gentlemen, from this point forward, you will not enter the courtroom unless Sergeant Pilgrim brings you out from the jury room. After breaks and at the beginning of the day, you will go straight to the jury room from the elevators. Please wear layered clothing. Sometimes it is cold in the jury room and in the courtroom. We have a refrigerator, toaster oven, and a microwave available for your use. Please bring snacks and your lunch. Unfortunately, there are very little available food choices around this courthouse. I will ask that you wear your juror stickers whenever you are in the courthouse. This is so the lawyers and the witnesses can identify you as a juror. From this point on, the lawyers, parties, witnesses, and anyone else associated with this case in any way, with the exception of my staff, are prohibited from having any contact with you whatsoever. So if you happen to encounter any such persons on the street or in the elevator, please do not attempt to communicate with them in any way, and do not be offended when they ignore you. They're not trying to be rude. They are simply abiding by the law. If for some reason you have contact with one of the lawyers, or if you inadvertently overhear something about the case, please notify my deputy immediately. Ladies and gentlemen, we will generally court from 9 o'clock until between 5 and 6:30 p.m. With a 1 hour break for lunch around the noon time, whatever makes sense. Sometimes it'll be 1 o'clock, sometimes it'll be noon. It just depends. For the sake of your fellow jurors, please arrive on time, as we cannot begin or continue the case until all jurors are present. If something unexpected happens and you absolutely cannot help being late, please call my office immediately. We will provide you with the number. You will reach out to Ms. Tomlinson, my judicial assistant. Again, you are not to discuss the case with anyone or allow anyone to discuss it in your presence. And I need to remind you not to watch TV or read newspaper accounts, no social media, no posting regarding the case. In other words, I'm not saying you can't watch TV, but if something were to pop up on the television related to this case, then you should immediately turn the channel, okay? Ladies and gentlemen, I believe it might be helpful if I give you some preliminary instructions concerning criminal law and trial procedure, which will apply to this criminal case. A crime is a violation of a statute of this state in which there shall be a union or joint operation of act and intention. That is, a crime is committed when a person violates a statute of this state by acting as prohibited while at the same time he has a criminal intention and no other defense excuses the conduct. A person will not be presumed to act with criminal intention. However, you, the jury, may find such intention upon consideration of the words, conduct, demeanor, motive, and all other circumstances connected with the act for which the accused is being prosecuted. The state cannot bring a person accused of a felony to trial unless the grand jury has first indicted that person. Grand jurors do not try criminal cases. They ordinarily only hear from witnesses or the state. When a criminal case is tried, the defendant has pled not guilty to the indictment. This plea of not guilty denies every essential allegation of the indictment and forms the issue or question that you as the trial jury will decide. The indictment and the plea of not guilty to it are the legal procedures by which the state brings charges against the accused into court. They are not evidence, and you should not consider them to be evidence. Every person is presumed innocent until proven guilty. No person shall be convicted of a crime unless each element of the crime is proven beyond a reasonable doubt. The state has the burden to prove each essential element of each crime charged beyond a reasonable doubt. In this state, a defendant on trial may or may not testify as he or she chooses. If the defendant does testify, you would judge his or her credibility by the same tests applied to any other witness. If the defendant does not testify, which is the defendant's absolute constitutional right, you shall not draw any inference of guilt from this decision, and the defendant's election not to testify may not in any way affect your verdict. Moreover, the defendant has no duty to call witnesses or present any evidence during the trial. If he or she calls no witnesses or presents no evidence, you may not derive any inference of guilt from such failure to produce evidence. In such case, you derive guilt on whether the state's evidence proves the defendant guilty beyond a reasonable doubt. Under our system, I have the duty as the trial judge to decide the law that applies to a case and instruct you on it. You have the duty as the judge to decide the facts in a case from the evidence and reasonable inferences arising from the evidence. In reaching your verdict, you also have the duty to apply the law to those facts. You decide facts from the evidence. The evidence has two parts: testimony of witnesses and exhibits. A witness means anyone who testifies in person from the stand. The exhibits are those documents, objects, or photos that the court admits evidence. You will have most of the exhibits with you in the jury room while you deliberate. However, there are some exhibits which cannot be sent to the jury room, so it will be important that you pay close attention to all of the exhibits admitted during the trial. I caution you that what the lawyers say during the trial is not evidence. Also, anything I might do or say is not evidence. I have no leanings at all in this case. My only interest is to have the case tried fairly according to the law and the constitutions of this state and the United States. You are the exclusive judges of the witness's credibility. That is, you decide the truthfulness and reasonableness of their testimony. You may believe or disbelieve all or any part of the testimony of any witness. You have the duty to decide what testimony is worthy of belief and what testimony is not worthy of belief. You should lay aside any preconceived notions and not decide a witness's credibility until the witness has testified. This is true no matter who the witness is, whether a victim of a crime, the defendant on trial, a police officer, an expert in some field or otherwise. But remember that the defendant has no duty to testify or present any evidence whatsoever. Rules of law govern what the court admits into evidence. If an attorney objects to the admission of evidence, I must rule on the objection and decide whether you can consider the evidence. You should understand that there are two ways that I can respond to an objection. If I say sustained, then that means that I granted the objection and you should not consider the objected to evidence. If I say overruled, then that means that I did not grant the objection and you may consider the objected to evidence. You should not infer or assume anything from either the lawyer's objection or the court's rulings. During this trial, the court will have to consider some issues outside of your presence. When that occurs, I shall excuse you to the jury room for a time. During these periods, the court will handle the matter as promptly as the law permits. These interruptions, ladies and gentlemen, may occur frequently or infrequently. They may occur very close in time to one another or far apart from each other. They may last for what feels like a short period of time or a lengthy period of time. I wish for you to understand that this is a common occurrence and ask for your continued patience when this happens during the course of the trial. Now, the procedure in a criminal trial is generally as follows. First, the lawyers for both sides may make an opening statement to you. This opening statement is not evidence itself. Remember, what the lawyer say is not evidence. However, it is a preview or an outline of what they expect the evidence to show. Following the opening statements, the state has the opportunity to present evidence to support the charges against the defense, and the defendants have the opportunity, if he or she so elect, to present evidence in his or her defense. This part of a trial is called each party's case in chief. In the state's case in chief, the state calls its witnesses and introduces any exhibits. When these witnesses testify, they may be cross-examined by the defendant. When the state has presented all of its evidence, the state will rest its case. Then, if the defendant elects to present any evidence, the defendants may call his or her witnesses and introduce his or her exhibits. Of course, when these witnesses testify, they be cross-examined by the state. However, the defendant has no duty to testify or present any evidence whatsoever. After the presentation of the evidence, the lawyers may make a closing argument to you. At this time, the lawyers will try to persuade you to decide the case in their favor. Following the closing arguments, I will charge or instruct you more specifically on the law that directly applies to this case. Then you will retire to the jury room to deliberate and reach your verdict. Ladies and gentlemen, this is not an exhaustive description of the procedure in a criminal trial, but hopefully it will give you a quick overview which will help you to understand the trial as it proceeds. It is your duty to follow any instructions that the court may give you during the case. Please remember to listen carefully to all of the evidence. Do not jump to conclusions before the parties present all the evidence. Also, please remember that during a trial, it would be improper for you to discuss the case with anyone or to allow anyone to discuss the case with you or in your presence or within your hearing. Also, during the trial, you should not communicate with the parties, their lawyers, or any of the witnesses or anyone else other than members of my staff. Under this rule, you should not engage in even social greetings or small talk with anyone involved with this case in any way. Again, understand that the lawyers and the parties should not speak with you as the trial progresses and will likely avoid speaking with you to ensure there is no appearance of impropriety. These restrictions also apply to the friends and family members of interested parties. During this trial, the law will not require that you be kept together during breaks for meals or at night. When you return to the courthouse from any adjournment for meals or the night, please go directly to the jury room. This will lessen the opportunity for an accidental meeting with a person that you may not know is involved with the case. If there is any coverage of the case by newspaper, radio, television, or other media, you should be careful not to consider it. Do not independently investigate any facts or visit any scenes depicted in the evidence. Do not independently research any law concerning the case. For example, you are prohibited from doing any such independent investigation or research concerning the case on behalf of the state, Is there a desire to offer this jury an opening statement?
All right, here we go, y'all.
Yes, Your Honor.
You have the floor to do so at this time, Ms. Winfrey.
Thank you, Judge.
You're welcome.
Promises. Promises of love. Promises of safety. Promises of a life. Promises to level up. Promises to lay your head down in a safe place. Promises, promises, promises. You will learn that there were promises given in this case. They were cloaked in profit, cloaked in greed. In their arrogance, predators target the weak who are caught in the schemes they devise. Their eyes watch in secret for their victims like rabbits hidden in rocks. They lie in wait seeking to devour. Ladies and gentlemen of the jury, that is what this case is about. This case is about these defendants. Defendants who built a proverbial house, if you will, a business on the backs of young women. Through the lure of their leaders' notoriety. Good afternoon, my name is Ernell Winfrey, as I stated earlier. I, along with my co-counsel, Chief Deputy District Attorney Adrian Love, Deputy District Attorney Grant Booi, represent the state of Georgia. First, I want to thank you for your patience during the arduous task of jury selection and in advance for your service today. As you see the evidence unfold in this case, you may see witnesses that may not be in chronological order. Don't be alarmed. Just stay with us to the very end. It will make sense. The players. Who are the players? John Michael Hakeem Gibson, also known as Cash Out. You will learn that he is the leader of this organization. You heard the word guys. It's just a group of people doing criminal acts for money in this case. You will learn that he's the one who set up plays and dates through cell phones, who lured girls in through his notoriety, who promised love and other things to get them to comply, who then turned coercive toward the end. Linda Smith, also known as Malika Benny, also known as Mama Cash Out. You will learn that the mother of John Michael Gibson. And you will also learn all of her involvement, even including being a manager of sorts, even making clothes for girls to wear as they sold themselves. Tyrone Taylor, also known as Brewski. You will learn that he is a cousin of Cash Out, John Gibson, and you will learn of his involvement. He was like a recruiter. You'll learn that he wanted to be close to someone who's famous to be somebody. You'll learn that he got involved with a young girl he never even knew before, with a promise of a safe place for her to lay her head. And you'll learn of his involvement through other witnesses in this case. The house that Cash built, literally and proverbially, it was built on exploitation, built on girls who were vulnerable. During the course of this trial, you will hear evidence about a criminal enterprise. Now that's a legal term. Don't get confused about that. Like I said, it's just a group of people committing crimes for profit. They organize themselves and they work together to do it. This organization works in the shadows, but it also works in plain sight. They built it by exploiting others, exploiting young women, fueled by deception and coercion, especially young women. Driven by profit and greed. Orchestrated by each of them. It was a criminal conspiracy that preyed on vulnerable young women for the purpose of making money. This case is about manipulation. It's about control, mental manipulation. It's about isolation. This case is also about violence. Now, you heard at the beginning of the trial all these different counts. You heard racketeering, you heard RICO. RICO is just a pattern that we're going to let they use to do these criminal acts. Several criminal acts they use to advance their organization to make money. The evidence will show that they operated in a group. You will hear about trafficking a person for sexual service, about pimping, pandering, tampering with evidence, obstruction. All of these criminal acts operating in concert to show that they operated together. That's all RICO is. You will hear from survivors, women groomed, women who are isolated and sold. You will see records and messages, financial transactions, witness testimony, victim testimony, all calculated and designed to profit off of human suffering. You will also hear from expert witnesses in this case. Specifically, you will hear from an expert witness whose name is Mary Beth Nelson. She is a witness of human trafficking, and she will give education and provide the dynamics of sex trafficking and to debunk the big myths about trafficking. She'll debunk the myth about sex trafficking being the proverbial white van that runs around and snatches women and children off the street and sells them into slavery. She'll talk about it being up close and personal and intimate. She'll explain to you the nomenclature or the verbiage used in commercial sex so you'll understand when the evidence comes out what is being said and what it means. From DNA experts, and it's up to you to judge the credibility and the believability of all the witnesses, to include DNA experts, and they will provide their findings. So, who are we really talking about here? This case centers around victims. And you heard many names at the beginning of the initial questioning when you all were sitting in the general audience. You will learn about Ashley Brown. You will learn that she's from Delaware and was a ward of the state, meaning she didn't have connected family. You will learn that her first play was a violent rape by her trafficker, John Michael Hakeem Gibson. You will learn that she ended up getting out of that situation by some brave law enforcement folks who stepped in and saw her and helped her get out. And it was her disclosure that all this broke over we were able to find other survivors and victims to bring these defendants to justice. You will learn about Jordan Adams, who was also a vulnerable young woman who had gotten kicked out of her home and was on the streets of Atlanta. She ran into Tyrone Taylor, also known as Brewski, who promised her a safe place to lay her head that night at a hotel in Industrial Boulevard. Unbeknownst to her, she's raped and she is sodomized. You will learn that Mr. Taylor, Defendant Taylor, he invited Cash Out over to have fun with her as well, and she was victimized all night long. You will learn she was also then put out on the street to go and sell herself. You will learn about Jessica McQuarrie, who is from Indiana, and she was involved with Cash Out during the early years. Dominique Lewis-House, you'll learn about her. Talicia Dubin, Frederica Spencer, Talithia Wright, Chantori Tolbert, Diamond Irving. You will learn that while each of them found themselves in this heinous situation, the one common thread is that while they suffered and survived, they were robbed of their dignity and cloaked in shame. You will show that the defendants in this case used threats of harm, physical harm, psychological abuse, financial control, and drugs to trap their victims. And we will demonstrate that this organized group had a command structure, specific roles, specific rules, but the person in this case was human beings. Human beings used over and over and over again. You will learn how Cash Out and his mother, Mama Cash Out, and the cousin Bruce, because it's all in the family, and how they work in order to obtain the This goal was to make money, motivated by money. The enterprise, it used tactics designed to recruit women, designed to control women, designed to exploit young women. Some of these women were often desperate. For the purpose of commercial sex, this is what they were obtained for. They lured them through a pattern of systematic plans. All of this, again, to gain money. The victims were groomed, isolated from their families, and coerced. And the people sitting behind this operation, they knew exactly what they were doing. The house that they built, the foundation is greed. The backs of the young women that made the money for them, they had no control of the money they made. Some of them subject to sexual violence, some of them subject to physical violence, all of them subject to psychological violence. Now, there's something important you will hear in this book. Two of the co-defendants, individuals who were once part of this very enterprise, will take the stand and they will testify for the prosecution. They will tell you what they saw, they will tell you what they did, and they will tell you what these defendants did. The witnesses were not promised anything in return, no bills, no promises, no favors. They are coming forward because the truth matters. And because they know what happened, they know it must be brought to the light. Their testimony will be of Kiera Adams. You will learn that she's been involved with cash out from even early on, since about 2014 to about 2022. Intimately involved with the inner and dealings of this organized way of committing crimes. She will describe to you in detail all that she did, her part in it, and all that they did, and their part in it. You will also meet Deanna Sanders. She was in a relationship with Cash Out. And you will learn that all of these girls believed that they were in a relationship with Cash Out. All of them learned and felt as though he loved them, or they were his girlfriend, or they were his wife, or soon-to-be wife. All of that. And Deanna Sanders will talk to you about her physical abuse at the hands of these women. You will have corroboration. You will have testimony, will be supported by a mountain of evidence, text messages, financial records, witness accounts, victim testimony, all of it pointing to the same conclusion. The defendants work together, exploiting human life for profit. Now, the court already instructed the burden is on us, it's on the state. The defendants have no burden whatsoever. They don't have to put up a scintilla of evidence at all. But I want to inform you to be mindful of the distractions, to not go down the rabbit holes. The evidence will be the evidence. I ask you to take notes, copious notes. We'll be here for a while. So you may not remember something from the first day to the last day. This evidence will be disturbing. I will admit the details will be hard to listen to and difficult, but they are necessary. Because at the end of this trial, the only conclusion the evidence will support is that the defendants ran a criminal enterprise that trafficked human beings. Defendants Taylor and defendants even sodomized and raped one of the victims. And this pattern of criminal behavior must be brought to light. And the defendants must be held accountable. You will learn that there is nothing that is that will not be disclosed or hidden, and that all will be made known. What has been done and said in the dark will be heard in the daylight. And what has been whispered in the ear, in the inner rooms, will be proclaimed from this witness stand. I will come back to you at the end of this case. And we will talk about all the evidence you heard. And we'll review all the appeal. And I will come back and ask you to find all of the defendants guilty. Thank you for your attention.
All right. Mr. Matthews, on behalf of Mr. Gibson, would you like to offer this jury an opening statement?
Yes, Your Honor.
You may do so at this time, sir.
Thank you. Ladies and gentlemen, good afternoon. I want to take this opportunity to thank you in advance for your time and your attention that you have given to us for these last 7 or 8 days in getting you all selected. We have selected the jury that is first jury to hear this case. I have an opportunity and a privilege and an honor to represent Mr. John Michael Gibson, along with myself and Attorney Carlton Matthews Jr. You have been impaneled, ladies and gentlemen, to hear and listen to evidence and law in this case. The trial of John Michael Gibson, a.k.a. Cash Out. Who is John Michael Gibson? He's 34 years old. He's an American rapper. He was born in Columbus, Georgia. He moved to the Atlanta area as a teen. Came from humble beginnings. He moved to Atlanta, Georgia, living with his mother and his siblings, east side of Atlanta, and he developed a love for music. He worked hard in the development of his craft. He didn't allow his humble beginnings, he did not allow where he was born, he did not allow his circumstances to stop his dreams. What were his dreams, ladies and gentlemen? His dreams were to write music, to write lyrics, to become an artist, sell records, to do concerts. Through his hard work, through his dedication, through his sacrifice, that came to fruition. He went in the studio, right here in the Atlanta area, started working, started putting his talents to work, putting his hard work and his sacrifice to effort. And that effort began to pay off. So he was 21 years old when music executive L.A. Reid invited him to New York City along with his local management to be signed. Mr. Gibson, he performed for L.A. Reid up in New York City. When he performed for them, they spent the entire day talking in a boardroom with industry executives. And they signed John Michael Gibson, Cash Out Records. When they signed Mr. Gibson, his first major song was a song by the name of Cash It Out. It was released in March 2012. It peaked at number 36 on the Billboard Hot 100. It was runner-up in the hip-hop department. And it topped as hot rap songs. Mr. Gibson toured all over the nation. Every city, every state. He was famous and still is. He was known. His songs were being played all summer long, all year long. And he did well for himself. He didn't just stop with making that one single. Made another single, released it in 2012, featuring Wale. Made another single in 2012, She's Working. These are songs that were played everywhere. Single released in 2014, Still Working. Released an album in 2014, Let's Get It. Features with Wiz Khalifa, Ty Dolla, French Montano, Rich Homie Quan, Waka Flocka. These are not just local artists, these are national artists that Mr. Gibson was working with and worked with. These are 12 tracks. This is a full album, Working. These songs aren't making themselves. Released another album in 2014 featuring Snoop Dogg, The Kid, DJ Bobby Black. He worked with these artists. In November of 2014, released their album at 11 tracks. 2014, another album, It's My Time. Keisha, another one, 2015, 17 tracks. Working, owning his craft, touring, taking care of himself. This is the house that Cash built. 2015, 8 tracks. Tracks or songs. Born for This, featuring Rich Homie Quan. Released in 2016. Song called Lil Baby. Released in 2016. Ran Up a Check featuring Lil Yachty. Again in 2016. Working. And it continues to go on. 2016. 2017. 2019. 2020. Those are all songs, albums, Mr. Gibson working, taking care of his business, and building his craft. Now, we are now here in this trial. He's been charged with count 1, a RICO. There's no conspiracy here. There's no criminal enterprise, and there's no structure to any criminal organization. The evidence will show that there was no organization that resulted in structure, resulted in there being a scheme, meetings, officers, the things that you would see in a corrupt, criminal, mafia-style organization that RICO was built for. The evidence is going to show that it goes back, in terms of this indictment, from 2013, 10, 12 plus years ago, to 21. The evidence is going to that this was put together in a RICO case. They put this together. Now let's talk about some of these persons that you will hear from. Now the allegation, ladies and gentlemen, is that Felicia Dewberry is pimped and pandered. She was interviewed by the district attorney's office several years later. 6, 7 years later. 22 maybe, 2022. And you will hear her tell you, ladies and gentlemen, that it was not Mr. Gibson, that it's this girl named Raven. That I went to high school with. So I encourage you to follow along and listen to what comes out. It's not a rabbit hole. It's not distractions. It's not going to be any of that. It's going to be asking questions and getting answers. It's this girl named Raven. I went to high school. You're not going to hear that Mr. Gibson recruited her, enticed her to be pimped or pandered. Jessica McQuarrie. Keep in mind the dates. 2013, 2014. So the evidence is going to show that she was interviewed in 2022, 8 years later. You will hear that she's in Georgia from Indiana to be with a man named James Jefferson. She did not come to Georgia to be with John Michael. You will hear that she was in communication with her mother, Christine Spurlock. And there was no pimping or pandering, no simple battery. So you listen to it. Some of it may be hard to hear. Our job is not to be brutal. Our job is not to demean. Our job is to get the information. To get the information so that you can hear it. And so that you can evaluate it. Dominique Wojciechowski. Still in 2015 now. Interviewed when? 2022. You see the trend? You're going to see the trend. 2022. You're going to be asking yourself these questions. You're all being interviewed around the same time. I will ask you to follow this case. You will not find any proof that Mr. Gibson committed a sex trafficking on Dominique Wojciechowski. Frederica Spencer and Tia Wright. I put them together, ladies and gentlemen, because they were together. They were together. The evidence is going to show that they were together when they came to Georgia from Alabama. You're going to hear, ladies and gentlemen, that they didn't come here because Mr. Gibson asked them to come here. You're going to hear that they came to Georgia because Deanna Sanders asked them to come to Georgia. And look at the date, August 1 to August 13. They were interviewed when? 2022. One in April, one in August. Now, when we get them on the stand, and when they come and sit in this witness stand, we're going to talk. We're going to have some conversation. What did they tell the police that morning? You will hear evidence that they're going to tell the police that they were robbed by 3 men at the Delk Road Baymont Inn. But you may hear something different when they take the stand. You may hear that they may say that they were raped by a guy or 2 guys. And we're going to talk about all those things. Because you will have an opportunity to listen to the evidence. You will have an opportunity to weigh the evidence. You will have an opportunity to listen to and evaluate credibility. And you will do that. There was no pimping and there was no pandering by John Michael Gibson of Frederica Spencer and Talithia Wright. Jasmine Brown. Mr. Gibson is charged with trafficking Jasmine Brown on March 27, 2018. March 28, 18. When she comes into this courtroom and you talk to her and she talks to you and she tells you what she tells you, then we're going to compare what she tells you to what she's told other people. You'll have an opportunity to listen to the evidence. You will have an opportunity to weigh the evidence. You will have an opportunity to weigh the credibility. And you're going to learn that Jasmine Brown is her own person. She did what she wanted. You'll have an opportunity to see text messages. So we're going to go through it. When we go through it, have an opportunity to listen to the evidence. You'll have an opportunity to weigh the evidence. You will have an opportunity to weigh credibility. Ladies and gentlemen, you heard a very long indictment being read. When you heard that indictment being read, there were multiple counts in the indictment. And in that indictment, which is not evidence, but it's a document that they put together, being the district attorney's office. You have an opportunity to listen to the evidence. You'll have an opportunity to weigh the evidence. You'll have an opportunity to weigh credibility. Count 24, they're charging Mr. Gibson with aggravated assault. They're saying that Mr. Gibson struck Ms. Brown with a belt that likely caused seriously bodily injury. Then if you just walk a few steps down the road through the path of the indictment, and you'll stumble upon the same allegation, charging Mr. Gibson with the same conduct, and they chose to charge it as simple battery now. Count 30. Beating with the belt. This is their document that they charged Mr. Gibson with. You'll have an opportunity to make it make sense in their indictment. Which is it? Is it either? How can it be both? Put them both in there. We're going to talk about all those things. I want you to listen carefully. You will not find any belt evidence. You will not find a picture of a belt in evidence. You will not find a description in any paper of a belt. Now, part of this case, they charged Gibson with keeping a place of prostitution. They're saying that on June 7th at 737 Alpha Road, that this place was a place to practice prostitution. The evidence is going to show, ladies and gentlemen, that there was a search warrant that was conducted at this address. You will not hear any evidence in the search of this location that they found condoms, lubricants, baby oil, no surveillance equipment. You're not going to hear any evidence that there were printed materials promoting illegal services, no ledgers or appointment books, no controlled substances. In the search warrant, they're going to say fentanyl drugs. Then they charged Mr. Gibson with illegal obstruction on that day in June of 2019. They're saying he refused to come out. The evidence is going to show, ladies and gentlemen, that he was in the bed. The evidence is going to show that they used some type of tear gas or some other technique or tactic, and that there was gas in the room. There will be evidence that he complied and came out. They charged him with willful obstruction. Ladies and gentlemen, they charged Mr. Gibson with possession of a firearm during the commission or attempt to commit a felony on June 6, 2019 through June 7, 2019. They allege that Mr. Gibson had on him or within arm's reach a handgun during the commission of a felony against and involving the person of another. And the person of another, you will learn that it says trafficking a person for sexual servitude. But the evidence, ladies and gentlemen, show that the only people in the residence at the time was Mr. Gibson and Miss Adams. The evidence will show that there was no person that alleged to have been trafficked was inside the residence or on the property. So the evidence is going to show, ladies and gentlemen, that a gun, but there's no alleged trafficked person in the residence. There's an alleged trafficked person on the property. But they find a gun and they say, oh, it's in possession of a firearm during the commission or attempted commission of trafficking a person. The evidence is going to show otherwise on that day. Jordan Adams, ladies and gentlemen, January 11, 2019 through January 12, 2019. They are alleging, ladies and gentlemen, that Mr. Gibson trafficked by coercion, that he physically confined her and restrained her. That's count 14. And that he raped her on count 10. And that he committed aggravated sodomy, alleging that he forced her to have oral sex on him. That's what's being alleged on January 11th, January 12th, seen. However, ladies and gentlemen, the evidence is going to point in another direction. What direction, ladies and gentlemen, is it going to point? Where is it going to lead us? Ladies and gentlemen, the evidence is going to show that Jordan Adams, she was handed a folder with 6 photographs. And of those 6 photographs, ladies and gentlemen, it included a picture of Mr. Tyrone Gibson amongst 5 others. Ladies and gentlemen, Jordan Adams picked out a totally different person that she said most like cash out. Now the allegation is that she was sexually assaulted all night long by Mr. Gibson, Mr. Taylor. But she picks out a photograph of someone totally different who is not John Michael Gibson. On it, she writes, most like cash out. But it doesn't stop there, ladies and gentlemen. It goes farther. In her recorded interview, the day she spoke with the police, the question was asked, well, what did cash out look like? Now, ladies and gentlemen, you guys have been here for 7 or 8 days. We're all human. We all have eyes. Our eyes have vision. And you've had an opportunity to see Gibson. You all came in here, you looked at Mr. Gibson. You looked at Mr. Taylor. You looked at Ms. Smith. And you eyeballed. Because that's just human nature. So they asked the question, what did cash out look like? She said he's tall. She said maybe 6 feet. 6'2". These are her words. But it doesn't stop there, ladies and gentlemen. The evidence is going to show that it goes farther. There was DNA evidence. You're going to hear from Ashley Hinkle. She's a forensic biologist with the GBI. So there was a sexual assault kit. And this is right after. There's a sexual assault kit that was done. It was preserved. And it was ultimately sent to GBI. And then one day, ladies and gentlemen, they got a tip, and they asked Mr. Gibson to open his mouth, and they swabbed the inside of his jaw. And when they did that, they preserved that. And then they sent it to GBI. So now they have the kit that they got from Miss Adams. Now they have the swabbing from Mr. Gibson. And what does the GBI do? What does Ms. Ingram do? What does the forensic biologist do? They do their science. When they do their science, they offer a report. And that report comes back, ladies and gentlemen, and we have an opportunity to read the report. The evidence, ladies and gentlemen, is going to show that John Michael Gibson is excluded from the data obtained from the major contributor genotype obtained from the second fraction from the vaginal vestibule swab. August 27, 2021. Mr. Gibson is charged with human trafficking and pimping of Kiara Adams for the purposes of prostitution. And this is in conjunction with a Gwinnett County case. The evidence is going to show, ladies and gentlemen, that that case was dismissed at the preliminary hearing in Gwinnett County. Sean Torrey, July 1, 2020 through July 11, 2020. We charged Mr. Gibson with trafficking, deception and coercion, pimping and pandering, keeping a place of prostitution, going back to that Alfred Road address. Now, what is the evidence going to show? The evidence is going to show that Sean Torrey Talbert got in her vehicle, ladies and gentlemen. She's 32 years old, and that she drove herself to Georgia from Texas in her own vehicle with her own money and with her dog. And she's 32 years old, not 18. This is not a case about minors. This is a case about adults. 32 years old, ladies and gentlemen. For 10 days, that's what they're saying, that he trafficked her. The evidence is going to show that Mr. Tyrone Gibson, John Michael Gibson, did not traffic Shantori Talbert. And we'll get into it. You'll have an opportunity to listen to the evidence, weigh the evidence, and weigh the credibility. We've already talked about the Gwinnett County charge. Now, you may hear jail calls associated with this case. Now, Ladies and gentlemen, you heard State talk about co-conspirators. Well, I don't know if they're co-conspirators or not. That's going to be for you to determine. That's what you're here to do. That's how they are being labeled. Kiara Adams, Deanna Sanders, you will have an opportunity to listen to the evidence on them. You're going to have an opportunity to listen to the evidence on them. You will have an opportunity to weigh the credibility. You will hear that they, on this indictment, you're going to hear that they were charged. Now, you heard the state of Georgia say, there have been no promises made. Well, we're going to get into whether there were promises made. We're going to get into whether they made proffers, whether they made sense to the district attorney's office, who was present, what were they facing. You're going to hear all of that. You're going to have an opportunity, ladies and gentlemen, to determine what was their motivation in what they said. What was their interest in what they said? Was there anything, or is there anything over their head? Or do they have to come in here and talk in order for things to go smoothly with their case? You'll have an opportunity to judge credibility. You'll have an opportunity to determine those things that motivate people to say whatever they're going to say. And then when it's all said and done, ladies and gentlemen, we're going to ask you to weigh the evidence, listen to the evidence, judge credibility. This is a very long indictment, which is not evidence. There are a lot of witnesses. But if you stay with us, which we know you will, we'll come back later. We'll tie it all together. When we tie it all together, we're going to come back and we're going to ask you to find Mr. John Michael Gibson. Not Gibson. Thank you.
Thank you, Mr. Matthews. Mr. Francis, on behalf of Ms. Smith.
Linda Smith is not guilty of the charge against her in this indictment. Linda Smith is not guilty of charges against her in this indictment. You will not see any evidence that Linda Smith coerced anybody into a life of sexual service. She did not deceive anyone in a life of sexual service. She did not gain financially from anyone's sexual servitude. That she did not subject anyone to sexual servitude. She did not harbor anyone in sexual servitude. And she did not maintain anyone in sexual servitude. All of the witnesses that will come and talk to you have already made statements. And when you listen to those statements, what you'll hear is they sort of barely knew this. She was around, but they sort of barely knew. No one's going to say that she did anything to force them into sex. You're not going to see a single text message that illustrates that Linda Smith forced anyone into sex. You're not going to see an Instagram message. You're not going to see a video. You're not going to see a Facebook message. You're not going to see anything that she forced anyone to deceive anyone into a life of sex. Linda Smith is not a part of a group of individuals committing crime. She's not. There's going to be no evidence that she had any intent to be a part of any group, that she had any knowledge of any organized crime, any racketeering, anything of that nature. Linda Smith received some cash checks from a few people over a period of years. She received cash checks from Deanna for a couple reasons. Deanna rented a room from Linda Smith with her own money. There's even a check that she wrote to Linda Smith. And Kiara used Linda Smith's car and wrecked it. And so, as a result of that, she cashed after the money for her car. So, she doesn't gain anything from any enterprise, she's not part of any enterprise. All of the statements that were made to law enforcement, when people were arrested, in this case was investigated, barely mentioned Linda Smith. Evidence will not be there. You'll see it for yourself. And at the end of the evidence, we ask that you find Linda Smith not guilty of all charges.
All right. Mr. Hoover.
Your Honor, let's take down the PowerPoint.
Sure. Look at the PowerPoint. Let's, if it's up, will you take it down? Thank you, Mr. Matthews.
Ladies and gentlemen, Tyrone Taylor didn't rape Jordan Adams. Tyrone Taylor didn't force himself on Jordan Adams. Tyrone Taylor didn't force Jordan Adams into prostitution. Tyrone Taylor is not guilty of what the state has charged him. Now, this case starts with Jordan Adams way before January 11th and January 12th. This actually starts a couple months earlier in Cobb County. You're going to hear evidence and testimony that Jordan Adams was found under the influence of cocaine, driving a vehicle with her daughter in the back seat. She was arrested for that. Because she was arrested, DFACS gave custody of her daughter to a man. You're also going to hear evidence that while Jordan Adams was out with that case pending, she stayed in the house with her parents and her daughter. Her father found a syringe full of drugs in the same house her daughter was in. You're going to hear evidence that because she endangered the life of her daughter, her father kicked her out of the house. Fast forward to January 11th. A couple months later, Jordan Adams happens to be at a gas station. Supposedly, she's telling people that she's going to the airport because she doesn't have anywhere to go. Goes to the gas station, runs into Tyrone Taylor. Goes up to Tyrone, hey, can you give me a couple bucks so I can get to the airport? Tyrone says, yes, I will help you out. Gives her a couple dollars. Tyrone says, hey, can I have your phone? Jordan says, yes. Willingly gave Tyrone her phone number after he gave her a couple dollars. Fast forward a couple hours, Tyrone's texting her, hey, what's up? Hey, what are you doing? Where you at? Jordan Adams says, I can't talk right now because I have a place to stay. I'm a little busy. I don't have a place to stay. So Tyrone goes, hey, if you need some help, you can come stay with us for a little while. Jordan Adams says, okay, tells Tyrone where she is. Tyrone doesn't have a car of his own at the time, so he's a friend to pick her up. Jordan Adams willingly gets into this vehicle. No one forced her to. Jordan Adams and the friend drives Jordan Adams to the Airway Hotel where Tyrone's staying. Jordan Adams willingly gets out of the vehicle. No one forced her. Jordan Adams goes up to the door, knocks on it, and willingly goes into Tyrone's room. No one forced her to. Now, once in the room, drugs are there. Everyone's, or not everyone, people are doing drugs, stuff is happening, that's it. That's all we know as of right now. Fast forward, Jordan starts to tell this story about what happens in that room. And depending on who she's talking to, her story changes. Now, ladies and gentlemen, you're going to hear the evidence is going to show you that the very first person that Jordan was communicating with was her mother via text message. The evidence is going to show you Jordan never said, hey mom, I'm being raped by two men, send help. You're never going to see evidence that says, hey mom, I'm being tortured and kidnapped by two men, this is where I am. Hey mom, I'm being held on my own, I have nowhere to go, nothing to do, please send help. What you're going to hear is Jordan said things like, don't call anyone because I'll go to jail. Or mom, I'm going to call a friend to come pick me up, I'll take care of that on my own. Or mom, don't say anything that's going to get me in trouble. The state wants you to believe that Tyler Taylor and Mr. Gibson are raping Jordan Adams from 6 to 12 hours, torturing her, abusing her, kidnapped her,
the very first person she talks to about this, and she basically says, don't call anyone because I'm going to get arrested. Fast forward to, January 12th, when she's talking to officers. Second story. Second time she has an opportunity to say or to tell what actually happened. Now the evidence is going to show you that she tells officers, as soon as she walks into that room, Tyrone made her take a shower, and then the rape started happening immediately. She says it's Tyrone is the only one raping her, and basically for about 3 to 4 hours, it's Tyrone continuously. He would get up, he was tormented, and then he'd go right back to her. First time she talks to an officer, that's what she says. Then she adds in, well, you know what? It happened up to about 3 a.m., then Mr. Gibson shows up. And now it's 2 men raping her from 3 a.m. to 9 a.m. that same morning. So with this story, she tells the cops that 2 men are brutally raping her, torturing her, physically holding her down to the point where she can't move or breathe. They're holding her to where she can't move or breathe. She is scratching them, she is fighting them, but she can't stop them. Sometimes both of them rape her together. Sometimes they rape her one by one. Sometimes they use condoms. Sometimes they didn't. And every time one of them would stop, they would give her cocaine. So ladies and gentlemen, the first time she talks to an officer, she says, 2 men raped me from 9 to 12 hours straight. They never really stopped because one of them was always doing something. But with a pause, I would have cocaine. So she's getting raped, tortured, and beaten, and drugged for 9 to 12 hours straight. A month later, she's talking to other officers. This time, she tells officers, well, when I got into the room, I took a shower, so I raped you for the first few hours. The rape didn't start until 3 a.m. when Mr. Gibson shows up. Story's already starting to change again. This time, she goes on to say, yes, they both raped me for all this time. They drugged me the entire time. I couldn't do about it. But I was scratching them. I was doing all that, but I couldn't do anything else about it. The first time they talked to the officers, Jordan Adams said, well, all I saw was cocaine. They kept giving me cocaine. The second time they talked to the officers, Jordan Adams, oh no, there was cocaine, there was heroin, there was marijuana, there was vodka, there was tequila. We were doing everything. Her story completely changes every single time. What we do know at some point, Jordan is not in that room with Tyrone. She's not in that room with Mr. Gibson. Jordan, 3 hours, let Jordan tell you, she is walking up and down the street from the hotel to the city. Now, ladies and gentlemen, this is why this is so important. While Jordan Adams was walking up and down the street from the Citgo, she was by herself. We have no idea where Mr. Gibson is because she kind of forgets about him and doesn't say anything, but she says Tyrone was in the hotel room. So Miss Adams is walking up and down the street by herself with a cell phone. She goes to the Citgo. We know the day before she was 100% okay with begging people for money so she can get help. But now, fast forward, she's been raped by 2 men she knows for 6 to 12 hours, depending on who she's talking to. She goes to the Citgo. She doesn't tell anybody she got raped. She doesn't go inside to the employee and say, hey, I'm being raped. I'm being kidnapped. They're forcing me to prostitute. She doesn't do that. For 3 hours, she's walking up and down that street, seeing people, communicating with people, but she never once said, help me, I have been raped. I am being tortured. I've been kidnapped. They're forcing me into prostitution. Ladies and gentlemen, you're also going to hear that during the time, Jordan Adams runs into the hotel manager. The manager goes out, what are you doing? Why are you walking around? Jordan Adams does not say, help me, I have been raped. She does not say, help me, I have been kidnapped. Tortured. They are beating me and forcing me into prostitution. Jordan says, you know what, I'm going to go get some cigarettes. That's why I'm walking, so I'm just going to get cigarettes. Those 2 times, Jordan could have told somebody, I need help. Again, she had her cell phone this entire time. Tyrone's nowhere around. Mr. Gibson disappears. She never called a family member and said, hey mom, this is where I am, come get me. I've been raped. She never called a friend, hey, this is where I am, location dropped, come get me, I've been raped. Citgo gas station, doesn't say a word. Hotel manager, doesn't say a word. Has a cell phone in her hand by herself, doesn't say a word. But the state wants you to believe that 2 men raped her for half a day, up to 12 hours, and she doesn't leave. just to give you an idea, ladies and gentlemen, you're going to see that the Citgo is half a mile from the hotel, the Airway Motel, where it used to be. That's 2,640 feet. Takes about 10 minutes to walk there. You're also going to see the Atlanta Police Department Zone 4 precinct was 410 feet away from the hotel. It takes less than 2 minutes to get there. And what's crazy, to get to the Citgo from the hotel, she passed the precinct. So what that means, for 3 hours, she's walking up and down the street, past the police precinct, never goes in. She never goes up there and says, hey, these two guys are raping me. These two guys are forcing me into prostitution. These two guys are beating me with the butt of a gun, and they're torturing me, and I can't breathe. But I want you to believe that they raped her for 12 hours. She's by herself the entire time. Now, ladies and gentlemen, you're also going to hear testimony that allegedly Tyrone, after he forced her out into prostitution, said, if a man picks you up, go to the Quality Inn. The Quality Inn is right next door to the precinct. Once again, she has an opportunity to go to another hotel to tell somebody, away from these two men, I'm getting raped and abused. She didn't do it. There's a reason she didn't do it, ladies and gentlemen, because she got kicked out of her house while she was out with a pending case for drugs, doing drugs and making money the only way she knows how. That's why she was out there in Fulton Industrial. But the state to believe that two men raped her, tortured her, beat her, choked her, suffocated her, crushed her body, and drugged her the entire time for 6 to 12 hours. Yet Adam still had enough power and strength and energy to walk up and down the street for 3 hours and didn't tell anybody about that. With the cell phone in her hand, nobody around. Now at some point an officer is going to ask her, well, why didn't you just walk away? Ladies and gentlemen, Jordan Adams' response to that is because they had my stuff in that room. The officer said, what was the stuff? Jordan Adams said, some of my clothes and charge. The state wants you to believe that two men raped her, beat her, and tortured her, and kidnapped her, and forced her into prostitution for half a day, up to 12 hours, and the reason she didn't leave was because she didn't have all her clothes in charge. Does that make sense? Absolutely not. Now, Mr. Matthews touched a little bit on DNA evidence, and he was right, the same kit was done, just like they swabbed Mr. Gibson's mouth, they swabbed Mr. Taylor's mouth. What they did is they put a little swab in there, get your DNA, sent it off to be tested. Ladies and gentlemen, through this investigation, officers also documented and collected gray bedding from the Airway Motel room. From the Airway Motel room. One used condom, swabs from both of their mouths, the rape kit. Now, with the rape kit, this is very important. They collected swabs from the vaginal vault, swabs from the vaginal vein, anus swabs, oral cavity swabs, inner thigh swabs, left side nail swabs, right side nail swabs, known head hair, left side nail clippings, and right side nail clippings. They collected all of that evidence, and what you are not going to hear in this trial at all is that they can find Tyrone Taylor's DNA on him. A man that raped her, beat her, and tortured her for 6 to 12 hours, depending on what she says and who she's talking to, they won't find DNA. Ladies and gentlemen, you're not going to see any pictures in this trial to where she's beaten. You're not going to see pictures in this trial to where she's scratched. She didn't have a hanging. She's not bleeding. She's not cut up. And she has the energy to walk around after being raped for half a day. You're not going to see any of that. On top of that, you're not going to have DNA that says this is Tyrone Taylor's, but they want you to believe the two men raped this young lady for 12 hours, abused her, kidnapped her, and forced her to walk the street. You've heard them present their case. I just ask you, please listen to everything presented to you in this courtroom for the next few weeks. Not only do you get to hear what our witnesses say, you actually get to see them when they say it. That's really important. Because I'm pretty sure Jordan Adams is going to get up here, she's going to start crying. You don't have to worry about just the crying. You get to see and hear everything that's going on. Before you make your final decision, please take your notes, write everything down, pay attention, focus on what you see and what you hear, And I'm confident you will find Tyrone Taylor not guilty of all the charges the state is putting on. Thank you.
All right. Let me just say this to all of you. If at any point you have to use the restroom, don't sit there uncomfortable or even let me know, okay? With that, are your first words?
State laws taking cities.
You do? Okay. We need a break for a few minutes. Okay, so we'll take 5 minutes.
All right, for the jury.
And you all let me know as well if there needs to be a break.
Don't play yourself.
Issues, I think that those two probably going to be but therefore they have these type of
Okay, so they ended up cutting the audio on this, and then there is not a day 2 stream up yet. What I've heard is that the housekeeping is likely going on, and that is not being streamed. So I've been told that this feed yesterday pretty much dropped out of the sky, and so we pretty much just kind of have to be on lookout. Well, I'll have to be on lookout for when day 2 starts. So in the meantime, we're going to go over to Karen Reed's charge conference to see what the hell is going on over there. If it becomes too long, I'll actually just end this stream and start another one. But I'm going to try and give them at least to the top of the hour, another 30 minutes or so to produce the day 2 of this trial. And that's just how we'll play it. So I'll get us a nice little note up here to pin. But in the meantime, we'll jump over to Karen Reed. And again, we'll just wait. Let me give you my thoughts though. Thus far, based off of the opening arguments, I will say that the state came out pretty strong. The prosecutor, I feel like she articulated her theory pretty well. And I'm very interested to see what type of evidence they're going to produce. She's talking about different promises that may or may have not been made. And Mr. Gibson being the leader, his mother being the manager, and making clothes for these women. And then the other defendant being someone who did a lot of the recruiting. She claims that they worked in the shadows and in plain sight, and that they preyed on young women to control them and use them. She alleges that there is a plan and a pattern, and they groom and isolated these women into prostitution. Now, Mr. Matthews got up and said, well, my client is a famous rapper. He had a bunch of hits. And he just really didn't have time for this. They're claiming or alleging a RICO and an enterprise, but there is no structure. There is no enterprise, and there are other women who are the actual culprits that they allege my client to be. Okay, he told us to pay attention to the dates. All right. The other I didn't take notes on the other 2 opening arguments because I was actually looking for the other stream, but it just really echoed what Mr. Matthews said, that there isn't enough evidence to support the charges that are there, and exactly how he recruited without no court. I thought that was interesting too. It just echoed a lot of what Mr. Matthews said, and that the witnesses did misidentifications. Their stories are changing. There is no DNA. So I think this is going to be a pretty interesting trial to watch unfold. We all love a good Fulton County RICO. And we're going to see if they're able to find one here. I think it's also going to be interesting to see how this trial compares to the Diddy trial, because it's a similar RICO involving sex trafficking. So I definitely want to compare the 2 wherever we can. But I think it's going to be very, very interesting. So I am going, at this time, I'm actually going to switch over to Karen Reed's charge conference. We're going to take a look at what's been going on over there. And then, again, I will still be on the lookout for day 2 of this cash out trial whenever that feed becomes available. I don't know if one of my mods can drop a comment while I look for Karen Reed. You can drop a comment that I can later pin to let everybody know what's kind of going on over here. We need to find, I need to go to Court TV. I like Court TV's thread feed better. Okay, here we go.
Issue that I have placement as far as there's already been within saying requested jury instructions or requested main practice, and then following the DG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding your compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context as main practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have this testimony from the stand, that initially she said she was fine with answering questions, but didn't want to get into any details. And then when the questions became centered on, or more centered on details, at that point, I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that arises to the level of the case instruction. So I would ask basically that everything on page 8 prior to the oral instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And, Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that,
Sure.
only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
What do you mean by that?
Or whatever.
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be possible.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates, now the home office introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to it's not numbered, your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified.
Withdraw that.
Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right, so tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up. Okay,
Your Honor, request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
speak up.
merely on third prong malice, because that's the only one that really applies to these factors. So
Okay,
the Commonwealth here, the first two prongs are essentially extraneous in this situation, and you don't see explanation. Avoid confusion.
do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intend to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, could we see what the court is proposing if you are going to alter the model?
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it,
Oh,
but I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so,
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it, and I'd prefer not to have to deal with it, so,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Valesky.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right, and this was allowed into evidence unobjected to. I thought we already had it, we didn't?
We have them redacted, so we
Okay.
redacted. It's on a thumb drive.
Okay, and the Commonwealth has seen it? All right, so they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, can I hand the
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a,
It's different.
okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually United.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Olau, in which he had similar issues and had, I believe, used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court a copy of it. Looking at some copy of the docket, but that may be somewhat helpful with the court's opinion.
Okay, was that on a murder case?
It was not, but it had to do with a felony motive homicide.
Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy of it?
Sure.
This is the
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instructions. So the Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in its argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence in Dayton, and then certain statements made in reference on the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says that she defecated to her.
Okay.
Whatever the exact quotation.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, quickly, check to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay.
do not like it.
Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you.
Excellent.
One less thing you all have to do today,
And
okay?
this is Mr. Ellis.
I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me? The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just, 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need a Commonwealth?
No, I wrote on it. I need the columns.
So this is a clean copy.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Ms. Gianetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah.
It should become ID.
Yeah, so we'll switch it back to ID, and this will just be 209? All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it redacted, the NNN? Or is it, no, it can stay that,
Okay.
right? 'Cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So that
our
has to be-
thinking is it needs to be sent back to letters for ID. I think
Yeah.
it's quite
So
important.
it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209,
Yes.
yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So, Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's an appropriate instruction to give in the final charge. What Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Leslie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023, Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, "So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt."
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete
and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally,
Very briefly,
keep your voice up, please.
yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen, mistakes can be made. It was immediately recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied. It was taken